everybody. It's August 20th, 2020. This is Mediation, the New Possibilities Hour, and we're very happy today to have MC Sungaila of the Buckhalter firm as our special guest. Before I introduce MC, I do want to make sure to mention that this is part of the Will Work for Food project. We don't charge for these wonderful webinars. Rather, if you like what you see, we ask you to contribute to a food bank in honor of the presentation. And MC will be mentioning a very special person fighting food insecurity in just a couple of minutes. Natalie, have we hit the $50,000 mark yet?
Jeff, we're so close. We're so close. We can do it. I know we can. We'll get there.
So we're at almost $50,000 raised through the sheer generosity of people like our viewers today and people who have viewed our past webinars. Thank you all so much for your extreme generosity to fight food insecurity at this very important time. Now, let's get to our guest for today, MC Sungaila. She is the chair of the Buckhalter firm's appellate practice group, and she just joined the Buckhalter firm in a very significant and wonderful career move for her. According to Chambers USA, where MC is ranked among the country's top appellate lawyers, clients describe her as a phenomenal writer, an excellent strategist. She advises on the business side just as well as she does on the legal side, a gifted appellate lawyer who consistently delivers bottom line results. She has been recognized for over a decade by the Los Angeles and San Francisco Daily Journal as one of California's 100 leading women lawyers, and she is a recipient of 2 back-to-back California Lawyer Attorney of the Year awards, sometimes called the Clay Award here in California, a very coveted honor. But even greater than that, in 2017, she was awarded the Ellis Island Medal of Honor. Other recipients include 7 United States presidents, Nobel Prize winners, star athletes, leaders of industry, artists, and others whose work has made a lasting impact on humanity for her combined professional achievements and humanitarian and pro bono work. And MC, we're so glad to have you here today. You are a true superstar. We're delighted to have you as our guest. Please tell us about Sir Bruno and the charity that he runs helping to combat food insecurity in the Orange County, California area where you live.
Thank you, Jeff. Yeah, I'm really excited to highlight Sir Bruno's efforts, which have been recognized by CNN, the Pope, and a whole array of other laudable folks. He is a chef at the Anaheim White House restaurant here in Orange County, but he's really most well known for the work he does on behalf of motel children and their families. So he discovered that there were children and families who lived in these motels because they didn't have enough wherewithal to have a security deposit or to pay for an apartment. And obviously there's no kitchen in the motels. So he took it upon himself to feed them dinner every night. And now he does it through the Boys and Girls Clubs all throughout Orange County. And he has chapters springing up all over the United States now replicating his model. And during the pandemic, he served his 1 millionth meal. And it's typical Sir Bruno in that when the pandemic hit and the lockdowns happened and his restaurant couldn't function, I mean, he couldn't act as a restaurant, he didn't really even worry about that. He decided, well, the most important thing was, how am I going to continue to feed the kids? And how am I going to continue to feed families? Because now there's an increased need during the lockdowns. So he just went to work on that and fed it, did his millionth meal, cooking food himself with some of the folks on his staff. And he had other restaurants join him as well, and they had huge drive-through lines where they gave food to a whole new branch of families in the county. So he really merits support. He's continuing to do this, as he always has for years. And if you'd like more information or to donate, his website for his charity is katarinasclub.org. caterenas.org. That's CATERENAS club.org.
Wow. Well, God bless Sir Bruno for doing that. 1 million meals for kids. And thank you so much for bringing this very worthy cause to our attention. Now let's talk about mediation and appeal, shall we, for a little while? And then we'll talk about it, then we'll open it up to questions from our audience. So first, MC, as an appellate specialist, why don't you tell us about the role that you play in mediations? Is it a behind-the-scenes role? Is it an active role? Pull back the curtain a little bit and please let our audience of mediators understand this better.
Sure. Well, I think it's both forms, and I have also served as a volunteer mediator for the State Court of Appeal as well previously. So I've been a mediator on appeal in a few cases and also have worked in mediations. So sometimes I'll give the example of me showing up at the mediation and being part of it. There's two most likely circumstances where that happens. One is right after a judgment, right after a jury verdict, where the parties are wondering, okay, now what are we going to do? Are we going to go to the mat and pursue it on appeal, or would we be better served to resolve it? Is there something, either we don't want the risk of the appeal, or we don't want to have to shell out the money for the appeal, or there is some solution we might be able to reach amongst ourselves that would be better than something a court of appeal could give us. So there's some kind of creative resolution we could get to. So in that circumstance, typically before there's an appeal, I'm usually involved, often at the mediation table with trial counsel and the client, partly because everyone wants to make clear that people are serious about appealing. So typically for the potential appellant, I will be there and I will be discussing with the mediator what my views are in terms of the appeal and where I think the strong points are for the appellant, and just kind of feeding that kind of strategy to the mediator to share with the lawyer for the other side. In the Ninth Circuit, I don't know if many people know, but in the Ninth Circuit Court of Appeals, they have a very robust internal mediator system. So very well-trained staff mediators on the circuit court will review new appeal filings as they come in. Parties usually have to fill out a mediation questionnaire, 2-page questionnaire, and the mediator will go to work to see if maybe there's some effort to have discussions. It's interesting, at the Ninth Circuit level, they're very interested in systemic litigation. So if, for example, there's an appeal pending in the Ninth Circuit, but it also has companion things still going on in the district court, that is a very good candidate for Ninth Circuit mediation, because they look at it as, we can resolve globally these problems between these parties and relieve some of the workload, both for the district court and for the Ninth Circuit through the Ninth Circuit program. So that's typically a really a red flag to them, that they want to call you in for some kind of conference. So in that setting, the appellate lawyers take the lead in that mediation. And first, there'll be a quick conference between all the parties, a telephonic conference, to see, is there a possibility, is there a point to mediating or not? The mediator has a lot of authority to extend deadlines. So if one side is pushed up against the wall because they have a brief coming due soon, they can relieve that pressure if it would be helpful for the parties to mediate, so long as both parties agree to that extension. And then after that sort of screening meeting, it'll either go into the mediation program, or it'll be released from the mediation program for parties to go towards briefing. And then if somewhere along the briefing people say, hey, we'd like to go back to mediation, we'd like to explore this now, a party can contact that same mediator, reach out to them, and have the mediator initiate contact, so it doesn't look like one party was, potentially interested in folding. So, so that's that procedure. They're very good at complexity, and they're very, very experienced. So, so they are a very great mediation resource. I know that some people may be cautious about mediators through the court system, but these folks are quite trained at what they do.
Great. Well, let's talk about the paradigm case, the tough case to settle on appeal. Somebody has a jury verdict in their favor. It's very tough to get a jury verdict reversed on appeal, as I understand things. Why would somebody with a jury verdict in their favor settle on appeal?
Well, a few things that I'd mentioned earlier. So one is the cost, right? Perhaps appeals are not cheap. And so it could be a couple $100,000 to respond to that appeal. And then it takes a really long time. It's about 2 years to argument usually and or decision in a case. And it's possible also that it wouldn't be a one-stop case in the Intermediate Court of Appeal. It could go to the highest court of the state or the land, which would mean 4 years till you get your money. So, so there's that delay aspect. And then, and the money aspect in the interim, both the costs of not getting the money and the outlay that would be required for the appeal. So those are a couple of things. Also, if you look at it objectively, you may say, I feel really strongly about my case, and the jury did too, but maybe there are some issues that would warrant some possibility of overturning or even getting a new trial in a case. And if that's true, then there's even a further risk of delay and time and money, and certainly you can't be as certain about your particular verdict staying. So if there's, for example, a legal argument, there's some question about the legal standard that was applied in the case, or it's an area of law that isn't altogether clear, and the parties had to create special jury instructions that were not model jury instructions, and it's in an area of law that's developing all across the country one way and the other, and it's not clear where this jurisdiction would go, that would be one where people on both sides might be concerned and wanting to resolve something. Maybe one side says, oh, maybe my jury instruction isn't going to stick. And then on the other side, also, institutionally, if a party is fighting these issues across many jurisdictions, maybe they will decide this case is not the best case to raise this issue, a novel issue in, because the facts aren't good for it, or they're concerned about the court. And so there are a lot of litigants who are institutional who like to choose their cases for appeal and like to select which ones are going to test the waters and which ones are not. So it's possible that you could get a resolution for that reason too, that this just isn't a good case institutionally to pursue an issue, and they'd rather not have it be decided by a court of appeal.
So MC, let's dig down into the emotional side of that a little further. We're lawyers, we're calm, cool, and collected about all these things. We can say, well, these are not model jury instructions, these are special instructions, this is an evolving area of the law. We can look at it in this more academic way, shall we say. But to the client, many times even sophisticated business clients just look at it and say, we won. What else is there to the story? What are some effective ways in your experience to communicate effectively with clients to get them to look at the rational side of things and balance with the emotional side of things? And in your experience, how can mediators help with that, particularly in a case where somebody has already won?
Yeah, that is a challenge, as you mentioned, Jeff. You can think about all these things rationally, but then there's the emotional investment, and not to mention the sense of vindication, right? I had this
Yeah.
position. All these jurors agreed with me, and who could disagree? So so there's that. That's very hard. I think one way to deal with that is to explain how the appeal is a different game now. Whatever was successful and, you know, swayed the jury is not the same kind of thing that the appellate judges will be looking at. The appellate judges don't re-examine the facts. They don't reweigh the evidence. They don't do what the jury did in terms of assessing the case. Although, of course, they're human too, and the facts affect how they look at a particular case, but that isn't their job in the case. And so while it may have been strong to the jurors as a factual question, and that's a good thing on appeal, the court will be looking at that a little bit more. They'll be looking at the facts, but just if there's evidence to support those facts instead of concluding something differently. And then it's really focused much more on the law. So while the jury is guided by the law and presumed to be guided by the law, they are not making decisions about whether they got the right instruction on something or whether a mistrial should have properly been declared or what have you. So I think that explaining to folks how the appeal is different, and that's where the appellate lawyer, whether they're in the mediation or just behind the scenes, can be very helpful, both to trial counsel to understand a risk to them, because sometimes they may have their own fees involved in the case also, so they have an interest in you know, where things are going to go. And just for them to be very clear-eyed when they're in a mediation with their client. By the time they've gone through the trial, they've drunk the Kool-Aid too and totally believe that there is no other way that this could have come out, usually, right? We won, yay, you know. So we're vindicated, of course, again, we were always right. So, which is fine, you have to be that way if you're gonna take something to the mat. By the time I take a case to oral argument, I believe there's no way we could lose, just because that's the attitude you need to have, you know, to win. So I'm not throwing shade on it, but it is important to say this is a different ball game. And I think having a appellate lawyer who does that all the time says, okay, here's how it's different. You know, here's what I'm dealing with. Here's what we can present. And here's a little more dispassionately, you know, where I see it fitting in the development of the law. I think another aspect, even though the intermediate courts of appeal are error correcting courts and they're not policy courts, they still, they're still looking at this case not totally on its own, right? They're looking at whatever the law is in existence that is stare decisis and what they're able to do that hasn't already been decided beforehand. So they're constrained by prior case law. And second of all, they are, especially in novel areas, interested in the outcome, not for these parties alone, but for others. How does this rule of law affect law generally? If they decide this rule in this case, how does it not only affect these parties, but others who would bring the same claims? And do they like that result? You know, it may be a result they feel comfortable with in this case, but if there are other outcomes that they, you know, may not be comfortable with down the line, they'll keep that in mind. And I think that's a big difference between an appellate court, which is dealing with the law, but also is concerned with cases and parties that aren't even before it in terms of how it decides something. A jury and a trial judge are only concerned with the parties in front of them, and they can make different assessments of the case based only on that case. And I think that's a different mindset that it would be helpful for people to appreciate. The decision makers are operating not only in a different realm, law versus facts, but they also have a different role and they'll be looking at it differently. I think the best way to explain it, especially at the Supreme Court or policy level, but even at the Intermediate Court of Appeal level, there's sort of this babbling brook of the law. You know, the law is just going along and you're like a pebble in that stream. And you want to show, if you're the advocate, that the outcome you want is sort of going with the flow. The law is going this direction and it should go with us. But I think that when the court's looking at it, it's always wondering about the ripples of that pebble in the water beyond, where it just fell, that is beyond the parties. And that is a attitude or a perspective that just isn't something that a trial judge or a jury is at all concerned with.
These are great tools that we as mediators can use, the babbling brook of the law, as long as we're not the babbling mediators of the law, I suppose. So let me ask you, MC, perhaps there's an apocryphal story, let's call it apocryphal for purposes of this conversation, that we as mediators could use really to put some flesh on those bones and give an example. Does anything particularly vivid come to mind that we as mediators could use in teamwork with attorneys to create certain levels of doubt or concern in the minds of clients, legitimately so?
Well, I think I will say one thing. I think that it's helpful to think about the different dispositions that could happen on appeal. That is, different results, right? So one result that creates uncertainty for both sides is a new trial. So if the result would be just absolute reversal and the money goes away to one party and the other party gets judgment, there's some sense of an ending so that you know that it's the appeal and, you know, whatever happens, I'm taking that risk for 2 years, but I feel strongly and I'm just going to go for it. But if the possibility, if another possibility of disposition is a new trial, then I think that introduces a whole new avenue of uncertainty, because you're not only talking about 2 years and reversal, and then maybe even another year if you're going up to a higher court after that, but then you're going back down for another trial in front of a new jury to do the whole thing all over again and spend a bunch of money for a second trial. So I think that potential outcome is one where it kind of overcomes the uncertainty caused by it. It has so many layers that it overcomes somebody's, one party's absolute certainty about their outcome, their verdict. Because you'd have to do this all over again and nobody can predict what another jury would do.
It sounds like you're co-mediating with Charles Dickens.
That's right. It's a Bleak House kind of thing. But I mean, I think that's important. I guess my message from that would be, when you're looking at the appeal, it isn't just you go, oh, there's an appeal and here's how long the appeal could take, and here's the percentage reversal rate on this type of appeal in this court, all of those things that you would typically use. But I think thinking beyond the notice of appeal to not only how long that appeal would take, but what could happen as a result of that appeal. Because that's always the first thing that we as appellate lawyers look at is, what is our disposition? And that's what the Court of Appeals is looking at too. What are you asking me to do? I don't just decide that an error was committed. I have to decide that it was prejudicial to the outcome. And then I have to decide what that means. What is the way to fix that? Is that giving you judgment outright? Is it cutting the award? Is it reversing it for new proceedings, either a whole new trial or for the trial judge to make some findings that the Court of Appeal can't make? I think as a mediator, it's important to think about those various outcomes and use that in the discussions.
Excellent. And we've been talking at least implicitly about appeals from jury verdicts. Are there significant differences where there are different kinds of matters reaching the appellate courts with different standards of review, such as de novo review when a summary judgment is granted?
Yeah, so that's an important point as well. There could be very important dispositive motions at the early part of a case, dismissing or granting summary judgment, and then that will be on appeal. And yes, there are different standards that apply to those, and where you have a standard of review that allows a more fulsome review by the Court of Appeal, that is de novo, starting over on legal issues, for example, then obviously there's more risk on appeal because the Court of Appeal could just see it differently, and they're entitled to see it differently. And in their view, on legal issues, the law is what they do, right? So they don't feel like the trial court or the has any leg up on them. If there's no sense of credibility assessment that the trial judge had to make, or really a actual fact finding as opposed to finding, no important controverted facts on a written record, that's something that the Court of Appeal feels equally comfortable doing. And so that plus the de novo review of the legal issues means there's a lot more at play on appeal.
Now, MC, let's go back to the question of jury verdicts and what you just said about weighing the credibility of witnesses and things that trial courts, at least in the past, have been in a unique position to do. Now everything's on Zoom, trials, arbitrations, hearings, everything is on Zoom and presumably recorded. So do you think that appellate courts may start to say, well, hey, let's take a look at the recording of the witness's testimony, which is exactly what the jury saw, and let's see for ourselves whether this person was credible or not. Do you think that we'll see some changes in the behavior of appellate courts as a result of these new technologies?
Yeah, I think that's an interesting question. That's an interesting point. It isn't clear yet whether the actual recordings, the Zoom recordings or whichever WebEx or whatever courts are using, I think LA is using WebEx, whether the actual recordings will be part of the official record. So there's still the official court reporter taking things down. That's the official record of the proceedings. But there will be these recordings. So I think there's a question about how will those be treated as an official part of the record or an unofficial part of the record. And I do think that as lawyers need to be thinking about that. If it isn't going to be part of the record, if something untoward happened during that, let's say counsel seemed to be engaging in some business they shouldn't have been, or in a trial that a juror was doing something that was misconduct that could only be shown by looking at the Zoom recording, then that would be something you as the lawyer would want to get in the record to make sure you could prove that. But whether the courts themselves are going to treat the Zoom recordings as an additional official record is still up for debate. I don't know that anyone's really gotten that far. I think everyone's just trying to figure out how to have them and do them in the courtroom. But I do think there's definitely going to be questions about that. If they were available to the Court of Appeal, I would think they would look at them. Just like if there are, video depots, that's possible to have them look at it. Typically, the courts of appeal just look at the transcripts of things. So the transcripts of the deposition, the transcripts of the testimony at trial. But where there's video evidence, that can be specially transmitted to the Court of Appeal. So it could be the same thing with this. I definitely would keep an eye on it because in my view, I think there are a lot of potential novel procedural issues with regard to remote proceedings and the recordings of them that just haven't even scratched the surface yet.
Any predictions?
Well, I do think that there'll be a move by counsel to be able to use those video recordings if possible. If they have access to them, I would, and it was crucial to their misconduct argument or something like that, I would really advocate that the lawyer put it in the record if they have access to it. The question is whether they do. It might just be from the court. So then it'll be up to the court to do.
It is now a occurrence from time to time in mediation briefs that through the miracles of modern technology, we get videotaped deposition excerpts and other video inserted right into the brief, and all we have to do is click on it and we can watch it. And let me tell you, it makes it for a much more engaging, sometimes even compelling experience than just reading the words on a dry page. So I wouldn't be surprised to see effective creative lawyers using that kind of technology to help bring things to life in the future.
Yeah, that's really interesting. So in the appellate realm, I didn't know that, but that's really interesting to know. I didn't know that was in mediation briefs. That's that's really helpful to learn. But in the appellate realm, since we're still, you know, sort of in the four corners and not multidimensional quite yet, we do hyperlinks to cases within the brief in some cases where it's very complex, so that you could just click on it and it takes you right to that page, so you can confirm that's exactly what somebody said or whether somebody is fooling with the record or not. And then also there's been kind of a movement lately to add more visuals to the briefs. May not be actual videos or, you know, things that are embedded, but because courts still get, while there's a lot of electronic filing, they still just get the paper copies. And there are a lot of old-fashioned folks on the bench, and like myself, who I would rather read the paper copies. So it's really hard to have a clickable video in that. But we do use a lot of visuals, and sometimes internally, you know, just charting things out or recasting things in a graph or a picture or something like that to help the judges look at it a different way. Here's a way to explain it, and here's a way to see it. So
Okay.
we're making baby steps towards what you're saying, Jeff.
Let's talk about other aspects of creativity, MC. You mentioned a few minutes ago the possibility of creative resolutions on appeal. And for those of us for whom appeals are not the bread and butter of our practice, clue us in, please. What are some of the creative approaches to settlement on appeal that you have experienced?
Well, I think that I think one of the avenues particularly is the one that I mentioned the Ninth Circuit sees, which is it isn't just this appeal, but there might be multiple cases with these same parties or these same lawyers in different stages of unfolding. And is there a way that you can globally resolve all of those and solve a lot of different headaches all at once?
Mm-hmm.
And sometimes that's something that you can get more, after you have something that's appealed, you have a little more sense of where things could go, and gives you a sense of how maybe the parties might be able to resolve something a little better overall, rather than waiting for each of these things to be worked out individually, possibly at odds with each other, and have to work with that. So if they have some control over the coordination of the results in those cases, that can be helpful. Also, I think thinking outside the box about what can be done. If there is, courts can just give you money or not give you money, or give you an injunction or not give you an injunction, pretty much. But about kind of, that's what they can do. But if there's something else going on between the parties that's personal or long held, or some other approach to things, maybe to business going forward between these parties, if they still want to have do business with each other, just thinking outside the realm of what a court can give you in terms of relief. And would that be beneficial to the parties, whether it's a global relief to a number of different cases, or whether, as you mentioned, Jeff, there are emotional aspects to disputes. There are other aspects that maybe the parties could work out something creative amongst themselves that a court couldn't do.
Do any apocryphal specifics come to mind?
Well, I definitely have had situations like in the Ninth Circuit, as I've mentioned, where there are a lot of, let's say, a lot of different wage and hour claims in a lot of different class actions or pagas or things like that. And one is on appeal and the rest are still pending in the district court. And you're able to work something out that resolves all of those at once. And that, both sides like that. So that works out well and solves a lot of litigation for both sides. I think that on the outside the box, thinking about, as I said, going forward, what can these parties do? Like reconfiguring their business relationship if they want to continue, and having someone work that out for them, which is, again, a court couldn't do. And I think sometimes that also gives the parties an opportunity to move forward. If they went through the court system, they might completely break apart because there's no guardrails and no guarantees from a third party, set up in third party mediation about how their relationship could look moving forward. And so maybe you open up new possibilities for people to carry on with their life that wouldn't be possible after they've had their, fight on the battlefield with their trial lawyer warriors and things like that.
And exhausted themselves in the effort.
Yes,
Right?
exactly. Mm-hmm.
So I want to ask you about book publishing, but first, MC, please tell us a little bit about the Ellis Island Award. That sounds like such a distinct honor. Please tell us about that for just a minute or two.
Sure. So the Ellis Island Medal of Honor is given every year to about 100 folks, and it's meant to celebrate the contributions of immigrants and children of immigrants to the United States. And so there's a broad array of backgrounds of people who get the award, but also a broad array of parts of society where they've made a difference. So it was meaningful to me because the ceremony is on Ellis Island at night, and there's a whole full military presentation and great speeches and a dinner in the arrivals hall at Ellis Island where my grandparents came to this country. So it was very exciting. It was very, very neat. So the whole ceremony is wonderful. And on the way back from Ellis Island, there's fireworks over the Statue of Liberty just for us. Wow. So it's a really amazing time. There's also so many amazing people. So my year, 2017, Buzz Aldrin, Indra Nooyi from Pepsi, the CEO of Pepsi, and Fareed Zakaria from CNN, Mindy Grossman, who has a huge online shopping empire, just so many different arenas from the arts to politics to business to famous astronauts who walked on the moon. So it's a really amazing array of people. And Sir Bruno, as I mentioned, is also an Ellis Island medalist as well. Charlie Zhang, who founded Pickup Sticks and is a big philanthropist in the, orchestral and music education for kids here in Orange County. He also is an Ellis Island medalist. So it's a great experience, but it's also really cool to meet so many people like that and to be inspired by them, and in some cases to become friends with them, because many of us share that same sense of possibility. Think of, success is possible, that kind of mindset, and just delivering on that, both professionally, but also in a humanitarian way. Every one of the people who receives the medal hasn't just achieved in their profession, but has given back and has done something significant for humanity or for their community.
Well, with your typical modesty and humility, MC, you failed to mention your particular accomplishment for which you were recognized and which earned you this honor. So if you don't mind, I'm sure everybody online is really curious. Please.
What the heck do you do? Yeah.
Yeah. Yeah.
So, yeah. What are you doing up there with Buzz Aldrin? Yeah, that's what I was saying. I was pinching myself. So I, as an appellate lawyer, I started my appellate career working on a case pro bono in the U.S. Supreme Court at the age of 28. And we won, and it was a case involving a state court judge in a small town in Tennessee who had sexually assaulted and raped court employees and litigants. It was awful, and it was a criminal civil rights prosecution. And the judge was released from jail. We put him back in jail after the Supreme Court got involved. But it was a really exciting case. And so my career started with a pro bono case. That's how I decided to become an appellate lawyer. And ever since then, I work on at least 2 or 3 pro bono cases every year. So after, 25 years, that's a lot of cases. And besides the very first one, I worked on the case before the U.S. Supreme Court, U.S. v. Morrison, on the constitutionality of the Violence Against Women Act civil rights remedy. I worked on Davis v. Monroe, which was a student-on-student peer sexual harassment case, whether schools could be responsible for that. And the answer is yes. And I also have worked on just many domestic violence and some immigration cases out here in California and in the Ninth Circuit. But I think the 2 cases I'm most proud of are an international case, my first international case in the Inter-American Court of Human Rights in Costa Rica. It was an action brought by mothers against Mexico for the disappearances and killings over many decades of women and girls in Ciudad Juarez. And actually, they're still very difficult down there, but we did get the first decision by any human rights court in the world of a women's rights treaty and Mexico's responsibility for these killings, not because Mexico did it and not because any agents of Mexico did them, but because their refusal to prosecute or investigate over decades itself created a lack of protection for women and girls and encouraged further crime to occur in that area that might not have otherwise if the system had become involved and engaged and actually prosecuted people. So that decision has reverberated across the world. There are other courts of human rights that have followed the reasoning and the application of that case. And then more immediately, the Inter-American Commission on Human Rights had another case pending before it. The commission is in DC, and it's just an advisory body. But there was a case pending against the United States in a domestic violence context for failure to enforce a mandatory arrest order that had been issued by, and a restraining order that had been issued by a court. So using the reasoning of the Mexico case, of the Cotton Fields case, the commission determined that the U.S., while it certainly has very good laws in place, it has statutes in place, it has the order issued by the court, but it fell down on the actual implementation at the police level and at the implementation level of those orders. And that in itself was a problem in terms of respecting and ensuring rights. So for that reason, the U.S. was also deemed to be complicit in the lack of prosecution and results from those orders. And so it establishes that you need to have all across the continuum, not just the rule of law and an order based on the rule of law, but actual enforcement of that. And that has had an impact on the local levels in this country in terms of, here's the framework of what a human rights court says we need to have in order to have a meaningful domestic violence system. And it's had an impact on the local level at state and counties. So I think those 2 cases are probably the ones I'm most proud of.
Well, those are pretty awesome accomplishments, and I'm sure that Buzz Aldrin was very proud to receive the same award as UMC. Let's turn to a little bit of a different subject, your book publishing. I know that you are you're very blessed with a really warm and loving relationship with your mother, and that turned into a book project, which has been very successful. And that has also redounded to your benefit in terms of your career and client service as well. Please tell us a little bit about that aspect of your life and career.
Sure. So, maybe like 2 years ago now, I just had this, I had a feeling that the world is in challenging times and it could use some positive input. And my mom has been sending me notes. She used to send me handwritten notes every day when I first started my law job at a law firm, every day I would get these handwritten notes, and across the top they would say Mother's Thought for the Day, and it would be a quote or some positive thing to just keep the day going, knowing that I would, you know, you're discouraged when you're starting out in practice a lot. So it was her way of encouraging me amidst all of these professional things and depositions and whatever. I would get this very nice handwritten letter every day, and she's since moved on to text messages, but she's moved with the times. But it was very helpful to me, and I thought, well, maybe this will be helpful to others to hear some of the same kinds of things that she has put forward, and particularly to young women and who are starting out as well. Maybe I can help them, you know, back up a little camper and keep going in the profession also. So I got my mom's permission. I edited many of them down and put them together into kind of a very design-heavy, colorful gift book. And we published it. And I published a second volume this year. And when I was publishing the second volume, I learned that the first volume got an independent book publishing award. So I didn't know what I was doing, and we still got an independent publishing award. So we're very proud of that. And I'm also proud that it has had a positive impact on families, and many you know, professional women keep it at their desk for a pick-me-up during the day, which is what I had envisioned. But also a lot of families work with it. Maybe their young kids read a page or, you know, a couple pages at night or to start their day, or people use some of the things in it and write their own notes, you know, in the lunchbox for people. So so it's exciting. It's exciting to have that happen. So the book is called Mother's Thoughts for the Day, and 25 Years of Wisdom. And it has a beautiful award-winning website as well. We also won for the best book website, so mothersthoughtsfortheday.com. And it's also been really nice because we've been able to contribute to the community through it. So it publishes in May for Mother's Day, both years. And during that month, a portion of those proceeds go to Sir Bruno's charity, Katerina's Club. And also I have given some of the proceeds to the Pacific Symphony, whose executive board I'm on, for their music education programs also. So we are giving back to the larger community through the books, and sharing a little bit of our positivity with the world as well. I will say that one of the two things that were unexpected that had a bigger impact from my doing this, one was that I really trusted my gut to do it. I really had no idea why I was called to do it, or even how to do what I wanted to do. But I had a vision for it, and I just thought, I don't know what's going to happen, but that's okay. It's okay that I don't have this big plan, or that, you know, I could just totally fall on my face. That could happen too. But I just trusted my intuition and just kept following it all the way. And that has had a really big impact on me in terms of how I make other decisions in my life, professionally. You know, just trust your intuition with things. If you really feel strongly about something, just keep pursuing it. And that's a gift that the whole publishing ethos has given me that I didn't expect. And then the second thing was the best outcomes were the unexpected outcomes, which were, like I said, the entire families coming together and reading the books and reminding them of their parents, and sort of bringing together all of these different generations in a family. That was not something I'd envisioned, but it's a beautiful outcome.
Oh, that's fantastic. Thank you so much for sharing some of those personal aspects with us, as well as the business aspects. We have just a few minutes left. We have about a dozen people on the video, on the webinar here. And if anybody has a question, I assume some people do, please unmute yourself and please ask MC your question.
Okay, so I have a quick question. I happen to be a special master of the Appellate Division, the Second Department in New York. And I, first of all, want to thank you, MC, for this wonderful presentation. We have a program, it's part of the Appellate Division, where we mediate appeals post-perfection, where the briefs are already done. Do you have any advice for mediating in that context, where the parties are more severely entrenched probably than they are pre-perfection?
Yeah, wow, you're a brave soul. Yeah, that is challenging. I hadn't mentioned this, but this is something that I've noticed. So if you're the appellant, I usually recommend either right out of the gate, sort of before the appeal is going to be filed, mediating, or after you filed your opening brief. If you mediate between the time you filed your notice of appeal and the opening brief, the impression created is that you've realized you're in a bunch of doo-doo and you don't have any good arguments for your opening brief, so you're weak, and the other side's going to take advantage of you. So normally, once you've gotten past that initial stage, you really have to present a strong appellate brief as an appellant to move the mediation forward. So I think that part, being at that part of the briefing, gives you a potential, another opening to mediate on appeal, which I don't think a lot of people consider. But having both sides fully briefed it, that's a whole other challenge, because everybody knows where all the warts are because they've looked at it in terms of each other's briefing, right? So everybody can do a very strong brief, but by the time you're done, everybody knows or has some sense of where the strong points are and where the weak points are on both sides. So on the one hand, there's an advantage to that, because whether they're willing to admit it or not, everybody knows. But at that point, everybody's saying, well, I put my money in. Now all I have to do is money for oral argument. Why don't I just roll the dice? So I think that's super challenging, unless, of course, you have a particular panel or something happens just before argument. I would say that's another caveat for resolving things. If usually out here, for this reason, nobody wants people monkeying around with who could be on their panel. So you usually don't know your panel until about 2 weeks before argument or very close to argument. And that is to avoid people from trying to suddenly be not available for arguments in hopes of getting a better panel. That's kind of the thinking from the bench side. But in that 2 weeks before argument, as you're preparing for argument, when you really revisit things and you can see some new pros and cons to the case that you might not have seen in briefing. And then you see the panel and you see what that panel has decided in similar cases. You might say, ruh-roh, maybe we should think about this, because that panel and the new approaches I've seen from preparing for argument create new avenues of uncertainty that I hadn't really seen before. That is, at that far down the line, I think you can do that. In your mediation, do the parties know yet who is going to be on their panel, or how close to
No, they
do
don't.
that?
They're too far out. Usually panels are 2 to 3 weeks before they're announced, and this is probably 3 or 4 months before oral argument.
Yeah. So what have you used to move that along, or to move people?
Some of the tactics that you actually talked about, and in the last case that I dealt with, there were actually 3 consolidated appeals in a very complicated med mal case, which had 12 parties involved. And what I did is I actually played one appeal against the other. And I said to the parties, you don't know what's going to happen if the court ends up deciding appeal 1 in this way. You could have an impact on appeal 3, and that could then impact your position. And then I also tried to target the parties who were entrenched already with the summary judgment decision. And I said to them, there's a certain value in terms of protecting your interest. Just looking at it from that standpoint, I understand now they said the thing, we won already, great, we've been vindicated. And I said, that's true, but on the other hand, there's always a possibility that could be lost. So you have to value that. And got some traction by doing that, but it's, as you said, it's a challenge.
Yeah, it's a challenge. Well, and summary judgments too, those are always tricky. Everybody feels like, oh, we've got summary judgment, it's great, but those are always very vulnerable on appeal generally, depending on the types of issues. So there's, there's something to say, just because you got summary judgment as opposed to a jury verdict's like, could be vulnerable.
Yeah. I wish the insurance companies that were involved in that shared your sentiments, but they're not as forgiving. So.
No, that's a whole other thing. That's why I say too, the institutional question is an important thing, right? I think at different points in time in the case, maybe the litigants are at different points internally as well in valuing and evaluating risk. And maybe they have a different view with regard to institutional matters. And so maybe there is an opening to do something, not because of any posture necessarily, you can just use that posture as an opening to have the discussion, but maybe something has changed internally and they could come up with a different number than they were willing to in the past.
So settlement on the courthouse steps applies to appellate courthouses as well as trial courts.
It does. There are some, well, there was one case recently that was set for argument. It was argued, and during argument or at the beginning of argument, the counsel said, hey, look, we're working out a resolution, but we haven't been able to do it yet. But we're going to go ahead with the argument because you want us to have argument and we'll present, but we're, planning to resolve this anyway. So it does happen like that close sometimes.
Wow. We have time for one more question, please. Mr. Vikram Singh,
actually, for Natalie and you, Jeff, can we all unmute ourselves and applaud for MC instead of just the silent claps for her achievements and everything she's done?
Oh, yes, sure. Thank you, Vikram. Where are you, Vikram?
I'm in Delhi.
In Delhi. Oh,
yeah.
Well, one of my favorite places. That's great.
Yeah, that's nice.
Anybody else? We have time for one last question.
I just want to agree that not only do you show that you're a brilliant lawyer, especially appellate lawyer, but you're clearly a well-deserving human being in terms of your humanitarian effort. And I really enjoyed both aspects of this presentation. So thank you for taking the time.
Oh, thank you. Of course, Jeff. I've known Jeff a long time and we've done work with Rand together. So of course.
MC, thank you so much. Let me echo and amplify everybody's comments. This has been a wonderful hour learning about your humanitarian efforts, your public service efforts, getting so many insights into the appellate process, how we as mediators can do a better job helping lawyers and their clients when we're mediating cases on appeal. Let me thank you as well for drawing our attention to Sir Bruno Serrato in Orange County, California, his efforts to combat food insecurity, especially among children. And that's Katerina's Club, CaterinaSClub.org. And we encourage everybody to support that worthy cause. And with that, we thank everyone for attending. And Natalie, thank you so much for organizing the Will Work for Food project and publicizing all these incredible webinars so well. MC Sungaila, thank you for a truly extraordinary hour. We are complete.
Thank you so much. Thank you all. Have a great day.
Thanks.
You too. Bye.